what to do when someone infringes on your trademark. There are many different approaches that may be taken to protect and enforce your mark. And the correct one often depends on when you first began using your mark in commerce and what parts of the world your customers are located. Without getting into the labyrinth of trademark law, I'm going to provide you with some basic actions that I've had success with. First, let's say that you find a similar mark that isn't providing the exact same goods or services that you are, but they're a little too close for comfort. In this situation, it may be appropriate to simply send a letter putting the owner of the mark on notice that you have a registered trademark. It's a good idea to enclose a copy of your trademark registration along with a description of goods or services that fall under your mark. The purpose of this letter is simply to put the other party on notice of the activities and services they need to stay away from to prevent you from taking legal action to protect your mark. But what if the infringer has already crossed the line into the exact goods or services that you provide? In this case, you're going to need to deliver something with a bit more teeth, such as a cease and desist letter prepared by an attorney and sent to them directly. This course of action is recommended in the US when it's clear that you were the first to use the mark in commerce. The goal of a cease and desist letter is to get the owner of the infringing mark to stop using that mark in any conflicting way. This sometimes requires a phasing out process that should be carefully written into a signed agreement and monitored closely by your attorney to ensure that the other side is living up to its end of the bargain. If the cease and desist letter doesn't work, and the infringer is attempting to register its mark with the United States Patent and Trademark Office, then your attorney will want to file a formal opposition with the U.S. Trademark Trial and Appeal Board. Of course, in order for this to work, you'll need to own a federal trademark yourself or already be in the process of applying for one. If none of the above seem to fit your circumstances, or if it's unclear which party was first in providing the goods or services, then another alternative would be to seek a settlement of the conflict. This can be achieved by agreeing on specific geographical areas that each party is permitted to use their marks. Another type of settlement agreement may be entering into a license agreement so that the owner of the conflicting mark must abide by certain terms and conditions that are acceptable to you in exchange for some type of payment for their use. An additional option to help with enforcement would be recording your U.S. or foreign trademark registrations with the Customs and Border Control in the jurisdiction where you want to enforce your mark. And finally, if all else fails, you may need to consider filing a civil lawsuit against the infringer. Filing a lawsuit is sometimes necessary to get the other party to stop its infringing behavior through a court order, known as an injunction. No matter which option you choose, the ultimate goal of any enforcement action is to resolve the conflict and remove the threat of diminishing the distinctiveness of the brand that you work so hard to create. But always remember that brand owners who don't enforce their rights or who take too long to do so are often prevented from stopping the third-party use of their mark. This is why proper monitoring and surveillance, as discussed in my video, The First Step to Protecting Your Brand, is not only recommended, but vital. As always, I hope this helps.